Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Y'all wouldn't believe me, but this is my third time doing this video. Both times, hour in, and either some glitch happened or it's choppy. I'm over it. So I'm not about to spend no more than 30 minutes on this, okay? So this is an update on Sean Combs' criminal indictment. Uh, I am going to go over the pleadings that were filed yesterday. For me, it's 11 p.m. Central Standard Time. So, yesterday on April the 2nd, the defense counsel has filed two motion in limines along with memorandums to support the motions. If you're not familiar with a motion in limine is, a motion in limine is simply a request that is submitted to the court in order for them to rule if specific evidence is, what's the word? If it's admissible. And the goal of that is to prevent somebody from entering in evidence, and that evidence could be hearsay evidence, it can be witness testimony, with all kinds of stuff. Well, I don't want to say all kinds of stuff, so let me just take that back. It could be photographs, it can be videos, it can be evidence of a defendant's prior bad acts. Okay, but in this particular case, these motion in limines were filed by the defense counsel because one, they're trying to deem an expert that the government hired as unreliable and not have her testimony involved in the trial. Okay. The other motion in limine that they actually filed was to preclude a summary of charts of evidence. Now, you're going to hear things like the rules of evidence, which is 1006 materials. And what that is under that specific rule, you can admit summaries of like voluminous books, records, documents, but it would have to be in a chart or a table or an index. You also can use some type of illustrative aids. Now, the thing with the defense counsel is the defense counsel doesn't want the government to pretty much sway the jury in a certain way. It can't be treated so the evidence that they are presenting, they don't want that evidence from the government to somehow determine the way that they're going to rule. He don't want to confuse them. They don't want to, paint Diddy as the monster that he is. It is a lot. It is a lot when it comes to this legal mumbo jumbo. But they do say if the actual government wants to submit some type of illustrative aids to provide them with enough time to review it, and when I say them, the defense counsel, and if the defense counsel decides that this evidence or these illustrative aids shouldn't be used in the trial, then they will file a motion for limine in order to request the court to make a ruling on whether these aids or illustrative aids would actually be admissible in court. And this is the process. So now we know that next month, here comes trial, and this is a normal procedure. But there is a deadline that uh, all pretrial motions have to be submitted. So the government is, you know, getting their expert witnesses together. The defense is getting their expert witnesses together. They're both exchanging their exhibits and their witnesses and all this other stuff. And in the event that they don't agree with something, or they don't want something to be used in trial, during the actual trial, then this is the time where they would file their motions in limites to preclude certain types of evidence. Okay. So I'm going to get into the actual pleadings. Like I said, I don't want to do more than 30 minutes because I've done an hour twice on this and I'm just exhausted. But I do want you guys to have a basic understanding of exactly what it is being filed. So, like I said, two motions for limines was filed on the second, and a motion of limine It's pretty much a request to the court to request that specific evidence or arguments be excluded from the trial. Okay. The goal is to prevent, once again, to prevent that evidence or to prevent that testimony from ever being presented in front of the jury. Hope that makes sense. All right. Now, going to the motion in limine to preclude the summary charts, I'm going to just start at the memorandum, and I'm not going to read all of it because I believe this one is 29 pages. Whew, no, this one is 5 pages. Thank God. I think the other one was 29 pages. But this is defendant Sean Combs' motion in limine to preclude summary charts, evidence, and for timely disclosure. So it says, Mr. Combs move in limine to preclude the government from offering into evidence at trial any demonstratives, summary exhibits, or other PowerPoint-like presentations that merely seek to organize or summarize the evidence for the jury. Any such exhibits would not constitute proper summaries to prove content under Federal Rule of Evidence 1006 and are inadmissible under Rules 107 and 403. Admitting such prejudicial exhibits at trial would allow the government to give the jury an argumentative preview of its closing arguments and equip the jury with presentations designed to commandeer deliberations. To the extent the government intends to use illustrative aids under Rule 107 or proper Rule 1006 materials, the court should order reasonable advance disclosures of these materials. For Rule 107 illustrations, disclosure should be at least 5 days before their anticipated use at trial, except for any demonstrative that are going to be used during the opening and closing arguments. And then for Rule 1006 materials, such exhibits should be disclosed with the government's exhibit list on April 14th, 2025. So this gives them the opportunity, one, to see exactly what it is that the government is going to use as evidence and what illustrations they're going to use, and that will give them a chance to rebuttal if need be, meaning that they will file a motion in limine and they will say, okay, I don't feel that this is admissible in court. And they would request for the court to rule on that. That's all that is. So that is that document, okay? Going into the second motion of limine, which is pretty, this part here is very important because when you're dealing with these personal injury cases, depending on what type of personal injury it is, this case is, surrounds sexual assault. And then we have cases where we're dealing with, slip and falls, or we're dealing with car wreck, or whatever the case may be. And you have specific doctors, I want to say, you have specific doctors who can, who are experts in that area of, expertise. Everybody has their niche. Everybody has their gift in which they are very knowledgeable in. Okay. So when we hire these experts, we're not just hiring any experts. We're hiring experts that are in this field, who have published articles in journals, who have clinicals, who have, studied this for more than 20 something years. And one thing that we do that it is requested is what they call is curriculum vitae. Pretty much it's like their resume that shows everything, and I'm going to show you guys an example because they did happen to attach her credentials to one of their declarations to kind of show. We'll get into that, but anywho's, what the defense counsel is trying to do is they're trying to discredit the government's expert witness, who is Dr. Don Hughes. So they also filed a motion in limine to preclude her testimony. Now, I'm going to read what it is that the memorandum that was prepared by the defense counsel as to why they are wanting to discredit Miss Dawn and why they are trying to get the court to reject her testimony in trial. So their argument is that one, Hughes' opinion will not help the jury understand the evidence as required by Rule 702A. The points under that they made was that Hughes will opine on topics well within the jury's everyday knowledge. Hughes will improperly and misleadingly instruct the jury on the law. Hughes' broad generalization about typical fact patterns will improperly mirror the testimony of the alleged victims and bolster their credibility. Hughes will improperly speculate on the motivations of alleged perpetrators of sexual coercion. Now, y'all, I done read this document already, so I'm so mad at myself. But anywho's, what they tried to do is one, they tried to say that her testimony is not needed because a lot of this stuff is common sense, right? Number two, they're trying to treat it as this is a man who was in a relationship with a woman. They go through things, and when they go through things, he ends up he apologizes, end up, making up to her, and they're back together, so on and so forth, right? And then they also are saying that pretty much if she does testify, then her testimony will once again give more leadway for the alleged victims and make their stories more believable. And I don't see how that's a bad thing, but I understand because this is defense counsel, on this thing. And then and it says that Hughes will improperly speculate on the motivations. Now, here's the thing. She is speaking in general. Like I said, everybody has their own expertise, their area expertise. Lawyers have the law. Not all lawyers are good lawyers. I'm just gonna be honest with y'all. But anywho's, law handles the lawyers handle law. Doctors handle specific areas in the medical field, and that is why the government chose Ms. Hughes. Another thing that they make another argument, they say Hughes' opinions are not reliable application of scientific principles to the fact of this particular case. And it stated that Hughes' opinions are not supported by the literature she purports to rely on, and that Hughes has not applied her methods to this case because she's speaking in general, okay? Which is not a bad thing in my opinion, because we all one thing that we can do, some of us can relate to Cassie's story or some of these victims' story. We can relate to reasons as to why we never came out with our story right then and there. We can relate to as to why we kept going back to that same man. And what she was trying to do is she was trying to explain that there is something psychological because everybody, there are some people, and I watch the comments all the time, well, why didn't she leave, or she stayed and she did this and this. We would never understand the brain, and there are some gifted people in this field that can do so. Okay, just like there are gifted lawyers, there are gifted teachers, there people are gifted in their own area of expertise. So, but once again, the defense goal is to discredit her, okay? Because they don't want the jury to paint Mr. Combs as the bad guy. Listen, and I'm just going to be honest with that. That right there sums that up, right? I'm going to read just a little bit of this introduction so y'all can kind of get an idea of where the defense counsel is on this. The prosecution seeks to call Dr. Don Hughes as an expert witness to offer opinions about typical behaviors among perpetrators and victims of abuse and sexual violence. Hughes has not reviewed or evaluated any of the evidence in this case. While purporting to offer only background information, her opinions are skewed to the advance the government's theme, and her testimony will mirror that of the government's fact witnesses. Her testimony's only real purpose is to support an inference that because the accusers in this case behaved in typical ways, they must be telling the truth. Hughes' testimony should not be admitted. It addresses no technical matters requiring elucidation by an expert. Most of her opinions relate merely to matters of common sense and everyday knowledge. For example, that victims of domestic violence often stay with their abusers, or that abusers exploit power differentials. As such, they are well within the ken of the jury. Her testimony will intrude on the province of the jury in deciding credibility and on that of the court in instructing on law. The heart of her testimony is a broad definition of coercion, but her definition conflicts with the legal definition of coercion that the jury will have to apply in this case. In several respects, her opinions are contradicted by the literature she cites as support and makes no claim to be applying a scientific me- um, methodology to the facts of this case. Hughes' testimony is advocating masquerading as expertise. Oof. The government wants an expert so that it can waive her testimony in summatation like a magic wand to cure the glaring defects in the fact witness's credibility. This will be continuing refrain as Dr. Hughes told you, as Dr. Hughes explained, and it will be highly effective. But this is not a proper use of expert testimony. It will not help the jury discover the truth. Hughes' testimony should be excluded in its entirety. Y'all, let me see how long is this background. Okay, I'm going to read uh the background and then I'm going to go to her what she submitted, what the government submit as far as what she will be talking about. And then I'm going to read the testimony of, well, not the testimony, but the expert witness that the defense is going to use to discredit Dr. Hughes. So, background: Hughes is a clinical psychologist and a board certified forensic psychologist and claims to be a leading expert on sexual abuse, interpersonal violence, victimization, and traumatic stress. The government is offering Hughes as a blind expert. She has not evaluated any specific victim or evidence in the case and will not opine regarding any specific victim. Instead, Hughes will offer opinions regarding such broad topics, areas as sexual abuse and victims' responses to sexual abuse, coercive control, coping strategies during and in relation to sexual abuse, delayed disclosure and memory of sexual abuse. Each of these topic areas, Hughes will opine on how victims of sexual abuse typically or commonly react to and recall the alleged abuse. For example, she will explain that victims often fall back on ingrained responses to power in order to stay safe, such as attempting to please or placate the abuser, that commonly victims experience a sense of mental defect, that disclosure of abuse is a process that occurs over time and delayed disclosure is common, and that gendered norms, tradition, and culture can also influence a victim's response to sexual abuse. She will opine that the victim may engage in avoidance, compartmentalization, minimization, direct forgetting, making excuses for others, self blame, and denial, and may also seek to numb and minimize painful sexual and abusive experience through the use of substances such as drugs and alcohol. She will also inform the jury that victims of domestic violence may stay with or return to rather than leave their abusers. Hughes will use similar generalized language to describe the actions of alleged perpetrators. She will explain that perpetrators often exploit pre existing power differentials for the purpose of perpetrating sexual abuse. She will opine that coercive control often includes a variety of physical, sexual, and or emotional tactics that together function to control the victim, including actual or threatened violence, sexual degradation, financial and economic control, exploitation of pre-existing psychological, traumatic, or financial vulnerability, can't even talk, gaslighting, and so on. She will explain that the perpetrators of domestic violence do not use randomly select means of control, but often use particular coercive control tactics that are targeted to exploit the vulnerabilities of their specific victim. She will explain that a perpetrator's coercive tactics and abuse are often interspersed with rewards, positivity, affection, and normalcy, which can create emotional attachment and psychological dependency. She will opine that the abusers may escalate coercive control tactics if they feel they are going to lose the victim or if the victim is trying to leave. Hughes will also delve into the motivations of alleged perpetrators. She will explain that the perpetrator engaged in self centered behavior to satisfy his own goals and desires, regardless of the needs, wants, and well beings of the victim. She will explain that perpetrators use coercive control to gain dominance across a spectrum of relationships, including with intimate partners and also in employment relationships. Remarkably, Hughes will also endeavor to define legal terms for the jury. She will propose definitions that are both contrary to the standard legal definitions and common English usage. She will tell the jury that interpersonal violence refers to dynamics related to coercion and emotional abuse that may not necessarily involve physical violence as commonly understood. She would tell the jury that sexual assault refers to contact and non contact sexual violations. She would tell the jury that voyeurism, even without any physical contact, may constitute a sexual assault. Most damaging to the defense and most confusing to the jury, Hughes will supply her own extended definition of coercion that focuses not on a serious harm or physical restraint, and they're saying that the legal definitions that will be given to the jury's instructions, but on subtle tactics such as micro regulation and isolation from pre-existing support networks and external influence that function to suppress that an individual's freedom and anatomy. As explained in greater detail in point two, Hughes used a broad generalization about typical behaviors. Divorce from any examination of the alleged victims in this case is contrary to the guidelines regulating Hughes' profession. Moreover, Dr. Alexander Sasha Barty, if called by the defense to testify, would explain that generalizations and vague psychological profiles are of little to no value in evaluating the facts and circumstances of any given case because there is no typical response to trauma and no typical response to rape and domestic abuse. Different people respond differently in different circumstances, depending in different life experiences, different psychological histories, and different educational and cultural backgrounds. For this reason, Dr. Bradley would explain the professions of psychiatry and psychology recognize that broad generalities tend to be of limited value in explaining the actual psychology or mental state of any particular individual. Dr. Bradley would also opine that Hughes's concept of coercive control is so broad as to be meaningless, and because Hughes is offering opinions without having evaluated the relevant empirical context or of any persons involved, her opinions have virtually no value. Now, I do have to agree with the defense on this point. People do respond in different ways when it comes to any type of abuse. That I agree with. I think that if the expert would have sat down with Cassie and sat down with the other victims, or even, well, yeah, how can I say this? Nope, I'm right. If that doctor would have sat down and herself studied, and not who, probably not the good term to use, treated, let's use that term, treated the victims to kind of understand why they did what that they did. I would see that her testimony would be credible. The only reason why I say that is because in our cases, when we hire experts, one, we do hire the expert that is in that field. But what we do is we try to hire an expert that treated our client. Because how can, now you can be a doctor in a certain area of feeling, you have general knowledge, but we need to know, as an expert, we need to know our particular client. Like, why was it necessary for her to get this, or him or her to get this, treatment? So in this case, when we're dealing with this, it would have been best to have gotten an expert to have sat down with the victims and kind of see where they were at, so that way you can apply it to this case. So I definitely agree. Now, I'm not taking anything from Dr. Hughes because she has the experience. She has done clinicals. And one thing that we have to do is we have to get their resumes, and we have to review it to ensure that they are an expert in their field. Like, what are the requirements? Clinicals, education, uh, published journals or articles in journals, so on and so forth. So, what the defense is trying to do is discredit Miss Hughes, and pretty much saying everything that she would be saying is common sense. Everything that she's saying is something that we don't already know, and it just would be a waste of everybody's time. I don't know about this one. This is very interesting. Now I'm going to turn to the declaration of Alexandra Shapiro, who is one of the attorneys, and she included her declaration, but in the declaration she included the exhibits, and it would be the disclosure as the expert witness of Don M. Hughes. So she does have her PhD. Now I'm just going to read her qualifications, okay? So her qualifications: Dr. Hughes is a clinical psychologist and a board certified forensic psychologist and a leading expert on sexual abuse, interpersonal violence, victimization, and trauma stress. Dr. Hughes maintains an independent practice in clinical and forensic psychology, is a clinical assistant professor of psychology in the Department of Psychiatry at Weill Cornell Medical College, served as the president of uh, the Women's Mental Health Consortium from 2009 to 2017, and is the immediate past president of the Trauma Psychology Division of the American Psychological Association. She has published, presented, and conducted professional legal and mental health trainings, conducted professional, legal, and mental health trainings on the topic that will be the subject of her testimony. Dr. Hughes' testimony is based on her 25 years of clinical and forensic practice assessing victimization, her trauma based education and training, and an extensive study of the empirical data and social science literature on sexual assault, interpersonal violence, victimization, coercive control, and trauma. Dr. Hughes' qualification, recent publications, and testimony in the last 4 years are further described in her curriculum vitae, which is attached as an exhibit. So this here, it does go into detail each of the subject areas. She talks about the sexual abuse and the responses. She talks about coercive control. She speaks about what else? Coping strategies during and in relation to sexual abuse, delayed disclosure, and memory. And this is her, I always say resume. This is her resume. Um, She's been doing this since 1998, y'all. Education, Doctor of Philosophy in Clinical Psychology, Master of Science in Clinical Psychology, and a Bachelor of Arts in Psychology. Professional training, her license and board certifications: New York licensed psychologist, board certification in forensic psychology, Connecticut licensed psychologist, North Carolina, and New Jersey. She's part of the American Psychological Association, the New York State Psychological. Look at this. Professional activities. And here's her clinical experience since 90, ooh, 92, 91, 90, 89, 88. Yeah, starting in 88. So she started out as a field intern and then worked her way up. That's impressive. Teaching. I love to see teachers, to my fellow teachers out there. So this publications, the influence of the internet on justice, especially in high profile cases, including the Trump trials, structured and clinical assessment of risk of violence, rape and sexual assault among adult women, degrees of memory of childhood sexual abuse among women survivors in therapy, abuse characteristics among childhood sexual abuse survivors in therapy. So these are all of her publications. All of her publications. And these are her professional, what is it, presentations. Forensic assessment of trauma in civil and criminal cases. So this woman is not somebody that does not know anything about high profile cases or criminal cases. She has the qualifications, she has the experience. She has published articles and journals and have presented these in college. And I know what people are saying. They're like, sh- she is a teacher and she teach in her field. That's what y'all, that makes the best teacher. When you have experience in that field, that makes you the best teacher. People don't realize that. That that's why I be telling my kids certain things. And I know I'm kind of going off on a rant, but that's exactly what I do. I love teaching and I'm passionate about teaching, but it's what I teach. Like I do GED, but I love being a notary. I love doing signing agent. So I'm teaching what I know. Now, as far as a paralegal, I can't teach paralegal classes because I have to have my law degree. In due time, I will, and I will be able to actually teach paralegal studies. I've been in this game for a very, very long time. And if I want to go teach teachers, I can do that because I have a master's in education. A lot of people don't know that. So this lady is teaching what she does on a day-to-day basis. She's been doing this since the 80s, since 88 to be exact. All right, so that's Miss Dawn Hughes. She's not to be messed with. Now the second attachment that Miss Shapiro attached is their experts, the defense experts. And this is the expert witness Alexander Barty. She is a board certified forensic psychiatrist. Oh, I thought this was a female. It is a male. I'm very sorry. His professional and academic experience and list of his publications are set forth in the attached. So I'm going to look at that. It says if he was called to testify, Dr. Bradley would offer the following rebuttal opinions in response to testimony from the government expert witness Don Hughes. Dr. Barty, can't even say his name, Dr. Barty's opinion are based on the totality of his relevant education, training skills, knowledge, and professional experience, including his assessment and treatment of patients, his forensic assessments, his work in consultation with professional colleagues, continuing education, and review of relevant scientific literature in his field. Oh, this is interesting. So he relies on generalization rather than individual assessment. And as such, her opinions are, oh, that's what they're saying, her. So Dr. Hughes relies on that. And that's what I was saying. So she's speaking in general and not per se to about the victim. Let's see. He also says that Dr. Hughes' anecdotal clinical experience is not reliable. It says to the extent Dr. Hughes bases her generalizations on knowledge purportedly gleaned from her own clinical experiences with patients, her opinions are questionable in further respects. Clinical evaluating patients in therapeutic settings are not investigators. They focus on the treatment of symptoms, not on the search for truth. They often form alliances with patients and professional bonds of trust so that therapy can take its course. The primary question is how the patient feels, not what behaviors actually occurred. Patients in therapeutic sessions can distort, exaggerate, minimize, or lie. Malingering and framing all well-known phenomena. That's hey, man. A further difficulty arises from the confidentiality associated with the therapeutic relationship. Psychologists, including Dr. Hughes, are generally not at liberty to disclose the details of patient sessions. There is thus a limited opportunity for anyone but Dr. Hughes to review the same patient data or for anyone to probe the conclusions she draws from it. Hmm. Well, he also says that Dr. Hughes' opinions are inherently biased, excuse me, and screwed. I said screwed, skewed. Let's see. Dr. Hughes undertakes a discussion of coercive control. The concept of coercive control is extremely broad and vague. Human beings attempt to influence each other all the time and in many different ways, whether in intimate relationships or not. The concept of coercive control is especially broad as Dr. Hughes discusses it, so broad as to be meaningless. Indeed, Miss Dr. Hughes does not appear to exclude any possible conduct from her discussion of coercive control. She states that coercive control tactics can be subtle and not immediately obvious to lay to the lay observer, and that the tactics are not one size fits all. Ooh. And they said Dr. Bardi is prepared to supplement his opinions based on independent medical examinations. He is a board certified forensic psychiatrist. He is qualified to perform independent medical evaluations of the individual complainants in this case. As noted above, such evaluations are the best means to understand the psychological dynamics of the particular individuals involved in this case. If provided the opportunity, he would promptly perform such evaluations and then supplement his opinions accordingly. I once again agree with this because I've never seen an expert that just gets on the stand and just speak in general and not in regards to the actual clients. I haven't seen it. So I do agree. Not discrediting any of her work, but it does not make sense to speak in general because this is a case of did he do it or not? But I understand what they're trying to do. They're just trying to say, as far as, in general, what certain people would go through, how they would act, so on and so forth. But once again, it's coming down to did he do it or not? Was it consensual? Yes or no? And I think the government is leaning to if the defense is trying to say, okay, it was consensual, Dr. Hughes would pretty much say, well, it can't be consensual because she wasn't in her right mind, or she feared that, she was going to be blackballed from the whatchamacallit. So I do get it. This is gonna be something else, y'all. Oh, so he been going through since 89 to God dog. Ooh, since 83. Got his bachelor's of arts from Harvard. He got his doctorates or his medical degree in 88. Okay. All right. Oh, Center for Justice Innovation. Yeah, so hey, I'm not knocking him either. I am not knocking him as well. Look at this. He was at Rikers, director of psychiatry at Rikers Island. All right now. All right. So these both of these individuals, they got the education. They definitely got the education and expertise. But as far as the government goes, I wish that they would have had Dr. Hughes meet with the victims so that way she can apply, you know, and she could have included, she could have spoken general but also included, but it would have been a stronger testimony if she could have spoken in regards to, Cassie and them. Now the only thing with that being, like they said, with her as a psychologist, you have that attorney, I'm about to say attorney, you have that patient doctor confidentiality. That would be the only thing that would be in the way. So I don't know how she would have overcame that hurdle. And I know that Dr. Barty stated that he has experience in that, so I guess he knows how to speak around that. I don't know, but I do get where the defense is coming from in this nature. But that's it right now. We're going to see a lot more of these filings. I don't know when the deadline is for them to have all of their pretrial motions, submitted, but it's cutting close. Even though we got like a couple of days, what, 30 days until we get this game started. But once again, uh, two motions have been submitted: a motion for limine to suppress, not suppress, but to preclude or exclude the testimony from the doctor, and then we also have a motion in limine to exclude the charts. What did they say? I'm looking on the docket. The summary charts of evidence. All right, so those are the two things that the judge is going to have to schedule a hearing on. I know as of right now, these motions of limine was posted on yesterday, so the government has to respond, and then the defense has to respond to the government's response, and then they can go ahead and have their hearing and argue this out in court. So April is going to be very, very busy. But y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.